Good morning, friends. Let us dive into another case law, which is newly added into the Advocate on Court examination. Friends, I am talking about case title Property Owners Association versus State of Maharashtra, which was decided on 5th November 2024. The bench was of Honorable Justice D.Y. Chandrachud, Justice Rishikesh Roy, Justice B.V. Nagarathna, Justice Sudhanshu Dhulia, Justice Jamshed B. Pardiwala, Justice Manoj Mishra, Justice Rajesh Bindal, Justice Satish Sharma, Justice A.G. Musi. So, friends, this is nine-judge bench case which has been decided by this nine-judge bench. The questions which is the correct interpretation of Article 31C of the Constitution after the judgment of Minerva Mills versus Union of India. In short, Minerva Mills. Second issue was whether privately owned property constitute material resources of the community which can be acquired and distributed by the state in furtherance of Article 39, subclause B of the Constitution. So, friends, I am again repeating the question. What is the correct interpretation of Article 31C of the Constitution after the judgment of Minerva Mills? Second is whether privately owned property constitute material resources of the community which can be acquired and distributed by the state in furtherance of Article 39, subclause B of the Constitution. Now, let us dive into factual background. The state of Maharashtra enacted the Maharashtra Housing and Area Development Act 1976, shortly known as MHADA, to facilitate the reconstruction of old, dangerous buildings and improve slum areas. In 1986, the state of Maharashtra amended MHADA to include Chapter 8A, which allowed for the acquisition of redeveloped properties for the erstwhile occupiers. Section 1A was also inserted in the MHADA, which states that MHADA gives effect to the state policies specified in Clause B of Article 39 of the Constitution. Article 39B provides that the state shall ensure that ownership and control over materials resources of the community are distributed to serve the common good. The constitutional validity of Chapter 8A was challenged in the Bombay High Court. On 30th December 1991, the High Court held that Chapter 8A was saved by Article 31C as it gives effect to the principles laid down in Article 39B. Article 31C says that laws giving effect to the principles in Article 39B and C cannot be struck down for violating Article 14 and Article 90. The appellants appealed to the Honorable Supreme Court, which on 1st May 1996 referred the matter to the larger bench because it found that interpretation of the Article 31C was disputed. On 21st March 2001, a constitutional bench of 5 judges of the Supreme Court referred the case to 7 judges bench because it observed that the correctness of Sanjeev Coke, which itself was decided by 7 judges, need to be reconsidered. This was because Sanjeev Coke case relied on a concurring but minority opinion of Justice Krishna Lar in state of Karnataka versus Ranganatha Reddy, also known as Ranganatha Reddy case, regarding the interpretation of material resources of the community. On 19 February 2002, a 7-judge bench referred the case to 9-judge bench consider reconsider the broad views taken by the 9-judge bench in Maftalal Industries versus Union of India regarding what type of property constituted material resources of the community under Article 39B. Now, let us dive into decision of the Honorable Supreme Court. The Supreme Court, by 7-2 majority, held that not all private property constitute material resources of the community in Article 39B and C to be acquired and redistributed by the state. It overruled the decision of Sanjeev Coke, which held that private resources also come under material resources of the community. The judgment for majority was written by Chief Justice Chandrachud. Now, Justice Nagaratna authored a separate, partially dissenting opinion, holding that all private owned resources, except for personal effects, can constitute material resources of the community, and private property can be transformed into community resources through processes such as nationalization or acquisition. Honorable Justice Dhulia also delivered a dissenting opinion holding that income and wealth inequality are enormous and the broad interpretation of material resources of the community adopted in Sanjeev Ko case is correct. All 9 judges held that Article 31C continues to prevent statues from being struck down for violating Article 14 and 19 if they give effect to Article 39B and C as interpreted in the judgment. The constitutionality of MHADA will now be decided by a regular bench based on the principle laid down in this case. Now, friends, let us dive into reasons for the decision. Invalidation of an amendment revives the unamended text. I am reading the line again. Invalidation of an amendment revives the unamended text. The interpretation of Article 31C was disputed because an amendment to Article 31C had been struck down and a question arose as to whether the text as it stood before the amendment continue to have effect. The Honorable Supreme Court held that when an amendment is struck down, the original unamended text is revived unless there was clear legislative intent to repeal the amended provision independent The court observed that invalidating the amended text without enforcing the original unamended text would create a gap in the law, leaving an area entirely unregulated contrary to legislative intent, which may lead to potentially absurd results and even create a constitutional crisis. Honorable Supreme Court ruled that when amending Article 31C, the legislature only intended to modify and not repeal the article. The court also observed that the unamended text of Article 31C had itself been challenged and upheld in Keshwananda Bharti. Thus, after the amendment to Article 31C was struck down in Minerva Mill, the unamended Article 31C stood revived. To hold otherwise would be to indirectly strike down language previously upheld in Keshwananda Bharti. Thus, Article 31C continue to protect legislation giving effect to the principles of Article 39B and C. Now, coming to correctness of Sanjeev Kok and cases following Ranganathan Reddy. The majority observed that Sanjeev Kok incorrectly relied on the minority view in Ranganatha Reddy. A concurring opinion by the minority of judges does not serve as binding precedent unless it is undisputed by the majority and forms part of the judgment's core reasoning. The majority in Ranganatha Reddy expressly disagreed with Justice Krishna Khanna Layar's interpretation of Article 39B and clarified that they did not adopt his view, thus precluding future reliance on his interpretation. Therefore, the five-judge bench in Sanjeev Court should have followed the majority view in Ranganatha Reddy rather than the minority view. The majority also held that Maftalal reliance on Ranganathan Reddy was purely incidental and limited to the social economic values espoused by Article 39B. However, Justice Dulia, in his dissent, held that as the majority in Ranganatha Reddy had been silent on the issue and concurring opinion in Ranganatha Reddy had reached the same conclusion as the majority, but only by a different reasoning. The concurring opinion in Ranganatha Reddy could be followed. Not all privately owned property forms part of the material resources of the community. Friends, I am again repeating, not all privately owned property forms part of the material resources of the community. The majority judgment held that while the Constitution embodies ideals of economic democracy, it does not prescribe a single economic model, leaving future generations free to choose the path toward economic justice. The majority reasoned that an interpretation of Article 39B, which places all private property within the net of phrase material resources of the community, only satisfies one of the three requirements of the phrase, that is, the goods in question must be resource. However, it ignored the elements that they must be material and of the community. It ruled that the word material and community must also be given effect. It held that the words of the community must be understood as separate from the individual. The majority, however, also held that the use of word of the community rather than of the state indicated a specific intention to include some privately owned resources. However, majority ruled that to hold that all the private property can be acquired and redistributed through state action would violate the constitutional protection of the right to property. The majority outlined certain principles to determine whether privately owned resources are covered by Article 39, subclause B. First one is the nature of resource and its inherent characteristics. Second one is the impact of resource on the well-being of the community. Third one is the scarcity of the resource. And fourth one is the consequences of such a resource being concentrated in the hands of private owners. In our separate opinion, Justice Nagaratna observed that all privately owned material resources should be first converted into material resources of the community and only then can be distributed to serve the common goods, except personal belongings. The state may transfer private property into material resources of the community either by way of nationalization, acquisition, or vesting of such resources with the state. The owner of private property must be fairly compensated for their losses when their resources are transformed into resources of the community. She also observed that any policy or law to enforce Article 39, subclause B is protected under Article 31C, but its implementation should not violate Article 14. Justice Dulia, in his dissent, observed that the phrase material resources of the community must be given an expansive meaning. It is the task of the legislature to decide what and when privately owned resources that serve the common good form part of material resources of the community. The social inequality that existed at the time of commencement of the Constitution still exists, and therefore the principles laid down in Article 38 and 39 cannot be abandoned. So this was all about this case law. Please read it thoroughly, listen it thoroughly, and get good marks in the examination. God bless you all to pass the examination comfortably.